We beg that you permit us, Mr. Chairman, to proceed to urge out the case for a constitutional reference.
Lawyers to Dr. Kizza Besigye logged a request for a constitutional reference to allow the Constitutional Court to determine matters including jurisdiction of the court-martial. This after the court-martial ruled that it has powers to try the matters before it, much as they were allegedly committed outside Uganda.
A reference on a number of matters. The ruling has itself interpreted articles of the Constitution and found them inapplicable. That role is a role that is reserved for only one court in this land, the Constitutional Court.
About the extent of jurisdiction of courts, and it states the jurisdiction of the courts of Uganda for purposes of this code extends to every place within Uganda. Notwithstanding subsection 1, the courts of Uganda shall have jurisdiction to try offenses created under section 23, 24, 25, and 26 committed outside Uganda by Uganda citizens or person ordinarily resident in Uganda.
Counsel to Dr. Kizza Besigye, Ernest Kalibala, told the court that courts of law needed to pronounce themselves on the impartiality of the court-martial, citing circumstances which gag it, including the court being a complainant, investigator, witness, and judge in its own matter.
On the impartiality, on the nature of the tribunal, and there is a question that arises about how impartial the tribunal, an organ of the defense forces, which investigates an offense, charges the accused, tries the accused, can be considered impartial. How can you be a judge in your own cause? How else can you find prejudice?
These also raise concerns on the contravention of the Articles of the Constitution 28 and the UPDF Regulation 69-2, which tells the court-martial to consult the High Command. These led to questioning whether trials before the court are consistent with the supreme law.
69.2 says that a court may adjourn, it is referring to the court-martial, may adjourn at any time to consult the convening authority on a point of law. I checked on who the convening authority is. It's the High Command. Now, if a court will adjourn or can adjourn or is empowered to adjourn or is allowed to adjourn to consult the High Command, Mr. Chairman, Article 28(1) would have no place. But this regulation cannot apply above Article 28.
Court rejected these matters after state prosecutors insisted the court-martial has the jurisdiction to try anyone who commits offense outside Uganda, citing the act which constituted the court, the UPDF Act. The court-martial chair indicated that all matters have been ruled about by the Court of Appeal and the Constitutional Court, thereby calling it a waste of time to okay for the reference.
One, that most of the points raised have been decided upon by Court of Appeal, which also sits as a constitutional court, but the state appealed to the Supreme Court. 2, that the alleged defect in a charge sheet is a matter that can be resolved through an appeal to the Court-Martial Appeal Court. In the results, this court finds that since most of Most questions raised were decided upon the Court of Appeal, which also sits as a constitutional court. And the matter is on appeal, especially in the Kabazuguruka case. This court declines to make a reference as prayed by counsel for the accused.
Even when the lawyers to Besigye objected the ruling of the court declined to give them audience, indicating that the appeal is only acceptable at the time of final ruling. Court proceedings to plea taking, in which Besigye and Lutale again declined to plea taking, was entered by court. Lawyers to the accused told court that it is the right of the accused to appeal and it can't be taken away by court.
That the appeal or the right to appeal should only be exercised at the final stage, as I understood it.